that lease, a sample copy that you can Real Estate Board of New York website, which is www.rebeny.com. rebny.com. The second most commonly used form is produced by a company called Lumber. www.lumberg.com. Lumberg. And Lumberg has a lease for every occasion. Anything from if you're subletting a room in your apartment to somebody all the way up to a commercial lease. They have two common forms of rent stabilized leases. One of them is, I think, a 4-pager, 5-pager that is simple and probably used by more landlords than not because it costs less than the other form they sell. The other form they sell has every insidious possible rider on it to make a tenant's life miserable. And it probably totals out at about 22 pages. And it was put together by a couple of attorneys who I think are a couple of insidious individuals, but I'm not going to talk about them. I'm not going to mention their names. But of course, if you went to the Lumberg website and saw the draft release, that release will have the basic information. The basic information that should be included in the lease is, of course, the name of the company that owns the building that is renting to you, your name, the amount of rent you will pay each month, when the lease begins, which is not necessarily the day you move in. Sometimes you can move in a few days early, sometimes you end up moving in a few days late. The landlord will usually prorate your first month's rent, the days you were not in possession. If at all possible, avoid when you move in the middle of a month. Landlords often will create leases that begin on the 15th of a month and end on the 14th of the next month. And for reasons that are too bizarre to go into, in the event you ever end up in litigation, there could be a lot of problems with that, calculating how much rent you owe. So try to avoid that. If somebody offers you that, say, I'd rather have my lease begin on the 1st, and you can just charge me for this month's rent, or begin at the 1st of this month and just charge me half a month's rent and say I'm moving in on the 15th. Something like that. Try to get a lease that begins on the 1st. In the event you end up in court, it makes life a lot easier. So those are the basic terms. The lease will have other terms in it that will say the landlord is liable for this and not liable for that. The landlord can sue you if you don't pay your rent. If the landlord has to sue you, this is the way they have to do it. That and then you'll have often what's called a rider that'll have certain rules, and the rules will say whether or not, and these are very important things, whether or not you can have a washing machine. If the lease says nothing about it, okay, you are a rent stabilized. Okay, let me backtrack. Whatever your first lease is, and optimally you should have a lawyer look at your lease before you sign it to see if there's any tricky things in there.
Like you?
Yeah. I was thinking I was the lawyer or the guy doing the trick. The lease, if you become a rent stabilized tenant, there's a rule in the rent stabilization law, and the rule is that the terms and conditions of your first lease are permanent to your tenancy forever, as long as you renew that lease every 2 years or every 1 year. Okay? So if you move in and your first lease doesn't have a provision in it that says no pets allowed, or as I am currently litigating in Queens County, there was no provision in the lease that says no smoking allowed. And now they've instituted a rule that says you can't smoke in the building, but guess what? My client can smoke away at will. And I am currently litigating that issue in Queens County. rules that are on your first lease stick for your tenancy. They can't be changed. So unless the lease says specifically no pets allowed or no dogs allowed, some leases specify you can have this type of pet, not that type of pet, a dog up to a certain weight. Bizarre stuff. I don't get into it. I've seen leases that say you can only have fish and reptiles in your apartment. Oh, reptiles? Really? Auto drag?
But there are exceptions to that. After 3 months, if you have a
Different. That's that's gonna be our holdover presentation that we're not gonna get to. That's a different rule, and that's a whole ball of wax. But I wanna stick to your lease. Excuse me? And what type of?
The first lease is the same.
First lease applies if you're a rent stabilized tenant.
Second building. And you move from one apartment to another. Like my
It depends. If you move from one apartment to another, and you're paying the same rent, the landlord doesn't make you sign a new lease, then the lease for apartment A becomes the first lease for apartment B. Okay? Everything would be the same other than the fact that it's a different apartment. Okay?
Is it supposed to be the same? That's what I'm trying to figure out. Is the second building supposed to go by the first building?
Not necessarily so. Depends on the facts of your specific case. So say that for later.
Okay.
Can we go back to what you had said about the first lease? If it says something, the second year, that it can't change.
Your rents, the terms and conditions of your first rent stabilized lease cannot be changed. So, if the terms and conditions of your first rent stabilized lease say, I can have a dog, you can have a dog, and then that landlord sells the building to a new landlord, and the new landlord institutes a rule, no dogs allowed, and sends you a renewal lease, and attached to your renewal lease, so remember, if you're rent stabilized every year or 2 years, you sign a renewal, the rent goes up a specified amount as set by the rent guidelines. Okay? So every 2 years, you're getting this renewal. Very often, the landlords stick these riders onto renewals. A couple of them are required by law, the smoke detector rider, window guard rider, that's supposed to be signed every couple of years. You have to certify there are no children under 10 in the apartment, so the landlord doesn't have to put window guards on your apartment. But often they'll like sneak in things like the no smoking rider, right? Even if your first lease had no smoking prohibition, even if they renewed it, even if you signed the renewal, and even if the rider, maybe you signed the rider and said I can't smoke in the apartment, and then later on you smoke in your apartment and they try to evict you, that renewal, that rider you signed are invalid. The terms of the original lease do not change. And that is the law, that is the rule.
What about rent control tenants?
Rent control tenants don't have leases.
Well,
They may have had a lease when they first moved in,
Yeah.
but there's no renewal lease when there's rent control. So the terms and conditions of that original rent control lease stay in the statutory tenancy. Okay?
Rent control is 90?
No, rent control is if you live in an apartment. If you lived in an apartment on certain categories of buildings on or before June 30th, 1971. Or often, nowadays it's usually your parents lived there and you took over the apartment from your parents. I mean, we're seeing less and less of the people who actually live with their parents. That's rent control. Rent control was replaced later on in the later 70s by rent stabilization, which is the program that many people have now, probably, I won't say the majority anymore of apartments, because a lot of apartments have been taken out of rent stabilization.
So rent stabilization started like in when?
Rent stabilization started in 1969.
Oh, 60.
Right. At one time, they both existed, and at another point, it's a long thing, I can't get into that now. I'll get sidetracked. So,
rent stabilization compared to rent control, what is the rent stabilization?
I'm not gonna talk about rent control.
No, rent stabilization, so.
Rent stabilization compared to market rate. The difference is, if you own an apartment that's not rent stabilized, what we in the trade call, you live in a market, in a fair market apartment. call it a trade. You live in a fair market apartment that's not regulated, you have a 2-year lease. At the end of the 2 years, the landlord doesn't have to renew your lease. If you don't move out, the landlord can start a case called a holdover case to remove you from that apartment. You don't have a right to stay there if you live in a fair market apartment. Yes?
What does a landlord have to do to notify you that you are in a rent stabilized apartment? And can you go into that?
You're in a rent stabilized apartment. And the first lease will say you are a rent stabilized tenant. That lease will contain a rider, which is a series. There's the form lease that you download from the real estate board or Bloomberg, and then there's what's known as the rider, which are pages added to the form that will have additional things to them. So by law, if you rent an apartment that is a rent stabilized apartment, it must include what is known as a rent stabilized rider. The rent stabilized rider has a breakdown in it, and that breakdown must say what the last rent stabilized tenant paid, and that the apartment still remains under rent stabilization, and that the rent was increased from what the last rent stabilized tenant paid to what you paid for the following reasons. And there are usually 3 major reasons for that. One, there is a statutory 20% increase for vacancy that a landlord is allowed to pay. So if formerly the apartment rented for $1,000 a month, the apartment can be rented for $1,200 a month now. Plus there's a little twist to that formula. There's a little bit of a kicker sometimes based. If the other tenant was there for more than 20 years, there'd be a little extra they could throw in, things of that sort. The second major reason why the rent gets bumped up is that the landlord made improvements in it. The landlord put in a new bathroom. The landlord spent $40,000. Then the landlord can get 1/40th of the price of that improvement, $1,000, and add that to the monthly rent permanently. So the $1,000 apartment became a $1,200 apartment, became a $2,200. You as a rent stabilized tenant though, you can move in, and the day you move in, you can go downstairs to the 5th floor and file an overcharge complaint and challenge this and put the landlord to their proof as to whether or not they really did the work. Because if it gets challenged downstairs at the agency called DHCR, the New York State Division of Housing and Community Renewal, which has now changed its name to New York Homes and Community Renewal, formerly known as the New York State Division of Housing and Community Renewal, which is still difficult on the tongue. And it was a pointless change of name, but the government does what the government does. You can file an overcharge complaint. You can file an overcharge complaint based upon improvements in the apartment. Then the landlord is put to their proof. The landlord must show that the work was actually done, that somebody was actually paid to do the work, and that the materials were actually purchased. And not only must they show receipts, they must also show proof of payment, canceled checks, credit card statements, to show that the money was that. Because there were many many cases where the landlords were caught en masse. They would do entire buildings with bogus improvements, with fake.
$10,000.
I've done cases on overcharges where the landlord claimed that, this contractor at such and such an address did it, and I went to such and such an address, which was in the Bronx once, and there was not a contract. I'm not going to discuss what I found there, but it was certainly not what the landlord claimed. So yeah, it's certainly bogus. You know what? The worst thing that's going to happen if you challenge your rent the day you move in is your landlord's going to get pissed. You know what? Your landlord's probably going to get pissed at you sooner or later.
Shouldn't you wait 30 days?
Why should you wait 30 days?
Because after 30 days, they have to. They get
You're
pissed off.
exercising your rights under the law. You can't be evicted for exercising your rights under the law.
But I thought they can try and take it to court before 30 days.
For what?
They don't want
Doing
you as a
something
tenant
illegal,
anymore
right?
after Even though you sign a lease, they can do
No
that?
such law. No
Oh,
such
okay.
law. So next thing to look for whether rent stabilized, how they calculated the rent. If they're supposed to give you the rider.
Well, like
But
I
they
went to
don't,
the
most of them
HRC
don't give
office
that.
and
You're not saying
many,
so?
most years, it said, no information given, like,
Because
They don't-
are those the earliest years of the printout?
84
If it's the
84
earliest-
till
if there's no way from it,
2010.
very often, the way it is, they passed a law called the Emergency Tenant Protection Act back in the early 80s. So DHCR came into being in 1984. In 1984, every landlord in New York City was supposed to register every apartment that was rent stabilized for the first time. Because prior to that, the registrations were regulated by the Rent Stabilization Association, which was the landlord body. And the punishment, the landlord's punishment, if they were a serial offender of overcharging tenants, is they would be expelled from the Rent Stabilization Association.
Wow.
So needless to say, this was not working too well, and that's why it's advocated. So every printout will begin in 1984. Very often, you will see no registration for 1984. Usually that means the apartment was rent controlled. And then you'll see often no registration for several years, then out of the blue, some registration will pop up for a rent stabilized apartment. I can't talk about it
can't look at it,
individually.
but it says not required.
Rent control.
So how do I know? So I guess my question is,
See,
how do I
you
know?
gotta understand, you will see different things on different printouts.
Yeah, no,
Because
but how do
very-
I know if he gave me a lease that is really a rent stabilized apartment, but he's
Let
shysting?
me talk to your private question later.
Okay.
I want to talk about lease. So, the other thing to look for, if your rent is above $2,500, very often it's an apartment that's been taken out of stabilization. And it becomes a fair market apartment. If you are the first fair market tenant, you are supposed to get a rider to your lease that says you are the first fair market tenant. This was a rent stabilized apartment. This is how the apartment went from rent stabilization to fair market, and it will have the breakdown. This was the last rent stabilized rent, the 20% increase. These improvements bring us over 2,500. We are no longer rent stabilized. We are fair market. You can still challenge that at DHCR and put the landlord to their proof that they actually did the work, they said the work, and that the calculations are correct. Okay? And I recommend if you're the first fair market rent tenant in an apartment, you should always do that because most of the time I have found the calculations to be incorrect.
So what happens then? Does it go back to a rent
Goes back
stabilized?
to rent stable, you become a rent stabilized tenant.
What if they just didn't give you the rider? They just
Still challenging.
And how about if you're having
If they don't give you the rider, it's a statute of limitations to challenge whenever he gets the rider.
say that again?
There's a 4-year statute of limitations on rent overcharges. A statute of limitations is a period of time you're allowed to sue for something. If I get in a car accident and I want to sue the person who ran me over, I have 3 years to sue that person. If I've got a rent overcharge and I moved in on July 1, 2010, I have until June 30th, 2014 to file a rent overcharge complaint against my landlord. Okay? If I am the first fair market tenant of an apartment and I moved into that apartment on July 1, 2016, all right, today. If I got the correct rider that says you're the first fair market tenant, the last tenant was rent stabilized, this is how we get calculated. I've got 4 years from July 1, 2016 to file my rent overcharge complaint. That means on June 30th, 2020 is the last day. If on July 3rd, 2020, I'm still like stuck in the last century. 2020. July 3rd, I said, damn, I've been overcharged. Too late, I can't bring my claim. Because I got that rider. If the landlord never put the rider on, statute of limitations to challenge that rent never begins to run. So if I move out and somebody else moved in, or if I stayed there, and July in 2025, I think I've got an overcharge, I can file an overcharge completely, because the 4 years begins to run when the landlord gives you that piece of paper. If you don't get that piece of paper, the 4 years never runs.
The rider?
The rider, and I've won cases on that issue also. The tenant never got the rider, I can file an overcharge via the court.
But most of these.
What's that? R-I-D-E-R.
But
Most of these landlords
you're
don't hear that.
Preservation, homes and preservation, to find that information and
Find what information?
when you're, how do you find out when you got destabilized? It's impossible. When your apartment became destabilized, was no longer stabilized.
There's different ways of figuring it out in different situations.
Okay, but there are different ways?
Yeah, but rather than talk about it in the abstract, it requires looking at a set of papers, and only by reviewing the set of papers can I come and say, this is the day when your statute of limitations begins to run. I'd have to see a set of, I can't do that in the abstract. I just want to talk about general principles right now.
What if you move in?
Yeah, what time do we go until today? We're good till 1:30? All right, we have plenty of time. We'll take questions. I'll take questions at the end. I want to go through the general principles first, and I will take the end.
At the end, it will be too late because I.
No, I'll leave at least 15 minutes for questions. I'm going to go on for 10 more minutes, and then we'll have 15 minutes for questions.
Yeah, so he can finish.
Well, let me finish, because otherwise I'll lose my train of thought. I want to cover the most important issues. Okay, we spoke about washing machines and pets. If there's no prohibition in the initial lease, they can't add the prohibition later. Today, you can include smoking in that as well. There are a lot of new leases, a lot of buildings are banning smoking. Which I think is unfortunate, but that's my issue. Preferential rents.
Yay.
A preferential rent is when a landlord has a rent-stabilized apartment, but can't rent that apartment for the legal rent. It happens.
But you're in.
Bad economic times, very often. So what will happen is you'll have an apartment, say, that has a $1,500 legal rent. Landlord can't get that. Or maybe the landlord likes the tenant. Okay? This is often the case too. And it's been there a long time, the landlord likes them, says, I'll give you a break on the rent. So the lease will say, there'll be a rider to the lease, and the rider will say that the legal rent for this apartment is $1,500, but the landlord for the period of this lease term is giving the tenant a preferential rent of $1,300. So for that 1 year or 2 year renewal term, the tenant pays the preferential rate of $1,300 rather than the legal rent of $1,500. Sometimes you'll see that in the original lease. In the past, these preferential rent provisions were worded in all kinds of weird, different fashions. And there was a lot of litigation as to whether the preferential rent was only good for this lease term and had to be on the next renewal forever, as long as the tenant was there, or whether the preferential rent only stayed for this lease term. A few years ago, DHCR changed the rent stabilization code, basically cut out all the loopholes. So unless the initial lease says this preferential rent shall be for the whole tenancy, then any preferential rent is only for the particular lease term, 1 year or 2 year. Okay? Why? Go back to what we spoke about before. You can't change the terms and conditions of the original lease, right? So if the original lease contained a preferential rent, it has a clause that says this is permanent, or if it's silent, oh, excuse me, no. The law says, now, if it's silent, it used to be, the court said, if the lease was silent about whether or not the preferential rent carried for the whole tenancy, the courts said that it was permanent. But they actually split, because believe it or not, the city of New York is split between two appellate districts. So if you lived in Manhattan or the Bronx, it was permanent. Or if you lived in Brooklyn, Queens, or Staten Island, it wasn't permanent. So they changed the law that now, unless the lease, the first lease specifically says, this is a permanent preferential rent, it shall continue for each subsequent lease renewal. Then whatever preferential rent and whatever language you have means your preferential rent is only for this lease term. And the next lease term, the landlord can go back to the legal rent. Now, you will often see fair market apartments where there's a fair market rent of $2,500 a month, and then the landlord puts in, you've got a preferential rent of $1,500 a month. That is pure smoke and mirrors, because if your rent is not regulated, the lease should just reflect what your actual rent is, because when that lease term ends, I can just raise it to whatever the hell I want to raise it to. It's just something it was thought up by the real estate brokers as something to make tenants feel good. Look, I got you this deal from them. It's a $2,200 a month apartment, but they're giving you a preferential rent of $1,500. I got you this great deal, and all of a sudden your real estate broker is your best friend. That's pure hope, okay? Preferential rents exist only within the context of rent-stabilized apartments. You'll see it in tons. It's become a popular concept. It's pure marketing. Pure marketing. So when you rent a new apartment, you should always go to DHCR to find out, get the printout, and find out if the apartment was ever rent stabilized, and if so, it's worth your while to follow rent overcharge claim just to the hell of it. The worst thing that'll happen is you'll lose. You still pay the same rent you always pay. Or you can come to an organization like Harlem. They'll help you analyze your rent breakdown and see if there is a overcharge. Last major issue I want to address are J51 tax abatements. J51 tax abatements are tax abatements that are given to developers who do certain types of construction in the city of New York. Meaning that during a certain period of time, usually 10, 15, or 20 years, after the building has done some sort of improvement or some new construction, that the building will pay a lower tax rate, called the tax abatement. So if the real estate taxes on this building are normally $1 million a year, if the building has a J51 tax abatement, the building will pay a lot less than $1 million, very often less than half of what the normal taxes on the building would be. The city's trade-off for giving you the J51 tax abatement, though, is that you, in exchange, are agreeing that you will make the leases rent stabilized. So all your tenants now become rent stabilized tenants. So I build a new building. I accept the J51 tax abatement. I've got 10 units. I rent those 10 units for $2,500 a month each. My tenants are rent stabilized tenants. When their leases expire, I have to offer them a renewal lease. I can only increase their rents by the amount set each year by the New York City Rent Guidelines Board. If I built my building and I did not accept the tax abatement from the city, I can charge my tenants $2,500 a month. If their leases expire, the market is better, I can charge them $3,500 a month. There's no control over it. The problem with the J51 tax abatement and rent stabilization is that J51 tax abatements are not permanent. they end, usually a 10, 15, or 20-year period, depending on various factors. When the J51 tax abatement ends for a building, then rent stabilization ends for that building. So that the rent stabilization for that building ends. So I rented in this building. I signed a lease for 2 years. Every 2 years, I sign a 2-year renewal. Every year, my rent gets increased 2%, or whatever the rent guidelines board says. 10 years come around, right? J51 tax abatement expires. My lease expires. Landlord goes, bye-bye, Charlie. I've got to leave. That's, if you're in a J51 building, that can happen. I've had that happen to many people.
How do you research?
What?
How do you research if the building is a J51?
It's supposed to be registered with the New York City Department of Finance as J51. That is not always the case. Sometimes the landlords fail to register the J51 status of the building.
And what is a J51?
That is called a J51 real estate tax abatement.
Even if
All
some,
the landlords have it?
No, only landlords who choose to take it have it. It allows you to get, in exchange for doing new construction or substantial rehabilitation of a building in the city of New York, up to certain standards of the city that are technical construction standards, you are then allowed for a period of 10 or 20 years to pay less real estate tax than what would normally be paid for that building. So one big reason why the landlord boots out the rent stabilized tenants at the end of the J51 period is because all of a sudden the landlord's got to pay a lot more real estate tax, so the landlord's got to start collecting a lot more rent.
even if the rent stabilized tenant was there for a long time?
No, these are new buildings. If
Oh, okay,
new, these are new buildings.
Unless, but you said that there's two ways you can get.
What's that?
Didn't you say you could get J51 two ways? If there's substantial rehabilitation?
Substantial rehab or new construction.
Oh, okay, but
Oh,
suppose,
you mean pre-existing? I'm sorry. If you were a rent stabilized tenant, if you're in a building that already existed and was substantial rehab, and you were a pre-existing rent stabilized tenant, you remain a rent stabilized tenant.
Oh,
If you
okay.
move in during the
You scared me there.
I'm sorry. If you moved in during the J51 period and you are a rent stabilized tenant only because of J51, you end being a rent stabilized tenant at the end of the rent.
Okay.
Thank you. That was a very good question.
When you-
And I forgot to cover that.
I want to know, when you J51, you said when do you become a J51?
Building?
Yeah.
When your landlord gets the.
When you start building your building, you get a building, you get a permit from the Department of Buildings.
Renovate.
Once you've got your permits from the Department of Buildings to build your new construction, you can file with the New York City Department of Finance for the abatement.
What happens if the landlord is, when people move, they may have had a 2-bedroom. The landlord's gut the whole apartment out and make rooms and rent rooms as opposed to
The
apartments.
quick answer to that, that's illegal.
Yeah.
We'll
You
talk
have to
about
call
that.
the
That's a
Department of
separate-
Buildings.
Yes.
If they don't tell you that they're a J51 and you enter into contract your original lease with them, and they don't tell you, what happens? What leg do we have to
You
stand
file
on?
a complaint with the HCR and you get, start an action to become, at the HCR, become declared a rent stabilized tenant.
Okay, and
And
if,
potentially you might be overcharged.
yeah, and then what about if, like, we got the report from the Department of Finance, and for several years it said that the abatement that our landlord got was only $1,100. Does the dollar amount matter? If they got it, if it's $1, it's for the whole building. If they got to tax something, everybody benefits. Thank you.
So doing, talk about Roberts and the old Schuler case. There's a tenant on the Upper West Side who won like close to $1 million and treble overcharges because the landlord didn't know about J51. I mean, is that, why don't more people do that? I mean, it seems like a lot of people have been illegally taken out of rent stabilization as well.
I think the bulk of those cases have been found and litigated or resolved. was there were several law firms did mass mailings
Yeah.
to these buildings. And if you live in one of them, you probably got letters from 2, 3, or 4 law firms looking for your case. Because many clients show me letters they received from these law firms. Yes?
If your lease says you shall use the apartment for living purposes only,
Don't run a business in your apartment.
if they have a daycare,
That's allowed. That's an exception under New York State
even
law.
though your lease was way back then?
There's a New York State law that says even if your lease prohibits it, you're allowed to run a daycare in your apartment.
Even if you don't live there?
No, you have to live.
No, they moved to Mount Vernon and bought a house.
If they're not living, you're allowed. You're allowed to run a daycare in your apartment if you live. If your lease says no business purposes, but you run a daycare in your apartment, you can run a daycare. You can't move out of your apartment and use your apartment as a
That's what
daycare.
they did.
That's wrong, and the landlord should evict them. That's the landlord's job, to evict them. In that circumstance, that landlord should be evicting those people.
Then I have a
Because they're in
daycare.
violation of the law, and because they're in violation of the law, they're probably lying to their insurance company, and their insurance policies are invalid, and if some little kid gets killed or injured in that building, they're gonna sue the landlord too. And if I'm the landlord, or I'm the lawyer representing the landlord, I would say, you better evict them right now, because you have potential liability here. Yes,
What
please.
about artists? We use our apartment to create art. Sometimes we have buyers come to look at our art. What would that be considered?
My-
Business?
My advice to people in that circumstance is to use discretion. I've seen ridiculous cases where landlords have tried to evict authors because they write books in apartments, buses, business. Such cases exist. I mean, use discretion. I mean, don't have a gallery show in your apartment every week. That would probably lead to your eviction. But if you have an occasional client come to look at a piece of work and walk out with it, I think you're not going to, you'd survive any eviction case.
Because musicians and practice in there.
Well, then you run into noise issues, and that's very tricky business.
No sense.
Noise is very subjective. Noise is very subjective. I grew up on one side of JFK Airport. I live on the other side of JFK Airport. Jet planes pass over my house every 5 minutes. People come to my house and they say, "Can you stand this?" And I'm like, "What are you talking about?" I don't hear it. I stopped hearing it years ago. My mind just shuts it out. So, like I said, noise is no, but people come and they're like, it's unbearable. It's like I have barbecues in the backyard. They're oh my God, I'm never coming back here. And I'm like, what are you? It's like, what's the problem?
I want to know if you have a rent stabilized apartment and if you sign a lease for 2 years and it's a percentage like 5%, 7%, not 20%. I don't know what's the difference.
Last year was 0% and 2.25 or 2.5.
Yeah, I didn't hear
Zero.
you.
Last year was zero. Last year was 0% for 1 year and 2.5% for a 2 year. And this year they haven't taken the final vote yet, but it's probably going to be in the same.
Which I should have been charged 0%?
For 1 year.
If you signed a 1 year lease between October 1, 2015 and September 30th, 2016, it should be offered to you at a term of 0% for a 1 year lease, 2.5% for a 2 year lease.
That didn't happen.
Yes, please.
What about succession rights, and would you become a fair market person if you?
No, if you succeed to the apartment, you become a rent stabilized tenant.
It's still according to that first,
Yes.
that lease?
Yes.
If someone should
If
die?
you succeed as the rent control tenant, you become a rent control tenant.
What?
But your successor would become
Rent stable.
rent stabilized. Rent control
One.
only can be passed on for one generation.
What if that generation didn't know?
I'll get to you. The gentleman was next.
Yeah, I haven't, but I have had books published already, when I was published, and I'm in the process of having another one published. Would that leave me exposed to being?
No, don't worry about it.
All right.
Only an idiot landlord would try to refuse. Yes, miss.
So in this new lease, I see they want you to fill out a W-9 form.
That's because the bank wants that for the security deposit.
I have to fill it out?
Yeah, it actually would protect your right to collect the interest in the event the landlord absconded and the account was sitting there.
Okay, so fill it out and give it to them as part of the lease.
Now, I'm telling you why they send it there. My advice to people is, I don't give up my social security. Nobody except who I am required to give
By
up to
law.
by law.
Right.
Anybody else is.
Right. It's
There's-
right.
They can do what?
Right, don't.
Give out your
don't-
social security number to as few people or entities as possible, including your landlord. You don't want, tell your landlord, I don't care about the interest, the 0.2% interest you're collecting on my security deposit. You can keep it. Thank you very much. Have a nice day.
Is there,
People get bent out of shape about their security deposits. I once had somebody who got paid $100,000 to move out of her apartment. We did the whole deal. In negotiating the deal, we had forgotten about the security. Her rent was $350, right? She goes, she's walking away with a check. She goes, "Where's my security deposit?" It's like, God, I'm checking your head for $100,000. Where's my security? People are very attached to their security deposit. They're like, I can get there.
Can you, so if you live in an apartment that was deregulated because of luxury control, and it's now market, can you still request a rent history and then?
You can always request a rent history. It's harder to challenge the deregulation by luxury control.
I see.
Because it usually was done by a proceeding before DHCR for which there is a record. So the landlord would usually be able to come up with an order of decontrol from DHCR. I'm not saying don't do it, but it's harder to win those cases.
And then how does the control happen? Because as I understand it, there's a level of 2,700 right now. The apartment must cross that, it must cross it on vacancy. What does that mean? How does the IAI work with that? Like, does the apartment, if the tenant was being charged 2,600, then it becomes vacant, and then the 20% takes over 2,700, does it become one
Deregulated.
control, or does it?
Deregulated.
Okay, just because once
If
the
the 20% vacancy takes it over 2,700, then it's deregulated.
even if there's.
Even if there's no improvements.
Oh, no, I mean, does that have to be vacant in order for that?
Yes.
Control to happen?
Decontrol can only happen upon vacancy, yes.
Oh, I see. The person must leave.
Only
that-
upon vacancy or upon luxury decontrol. Those are the only two ways you can deregulate when they want.
I brought my lease to get in this building here. I don't know what floor, fifth floor or whatever.
Fifth floor?
But I brought the lease to get a little guidance in terms of what I'm doing. They told me they couldn't give me no,
They're not lawyers, they can't give you advice, they can only hand you the printout.
right.
They're state
So
agencies.
where do I get
Legal advice, go to Palante. LCI and staff will be happy to help you and look over your paperwork.
it's right on here.
On 126, what is it, like right down the block, 2
Yeah,
blocks?
Main building, across from the main
Towards
building.
Amsterdam.
Yes, ma'am.
The question is, when your rent control tenant, your parent succession right, and you didn't know that you had the right to rent control and you signed a lease, can you go back?
Yes. You challenge it.
How long?
If your rent, if your mother was rent control, she moved out. And actually, I've done this, this used to be, now there's fewer rent control people. This was very common.
Do the name have to be on the lease? No.
Who's name?
Let's say if the person died, and let's just say it's her, and it was her mother who passed away. Do her name?
No.
Oh,
No, I move in with my mother, right? My mother's name is Gina Bianchi, right? Gina Bianchi dies. I lived with my mother for at least 2 years before she died. I'm the successor tenant.
But in the meantime, you signed a lease because you didn't know that you rent control protected, can you go back?
Yes.
is
There
there
were
a,
many instances where people didn't know they were rent controlled for a lot of different, many times, a lot of buildings a lot of landlords went bankrupt in the late 80s and early 90s, and a lot of buildings went into receivership, and a lot of records got destroyed, and it's impossible to find the DHCR records for a lot of buildings because the basement of the DHCR office in Jamaica was contaminated with asbestos that destroyed tons and tons of records back in that era. So a lot of stuff was lost. So very often stuff will come up and it's like, oh look, this is really a ring. I came across a case last year, and I was stood to make a lot of money, except that the tenant's aunt, who is also a lawyer, decided to take over the case. So I got shut out of a potential fee on that one. But that was a good one. I was up in the Bronx, and that would have been a very. I had it valued at about $150,000 overage. Oh.
Wow.
Yes.
Quick question, if you're a non-traditional family member and the person you were living with almost close to 2 years because that person had to go to the hospital, what rights do you still have if it's not quite 2 years? None.
2 years.
Even if that person went for rehab, it was going to
2
come
years.
back. 2 years.
They're very strict about that, but it's got to be 2 years. Liz, you got a question?
Is there a, what I was asking, like, a time limit from when the person died? Like, okay, it was my daughter, and I did ask them about, she had written a notarized letter asking them before she passed away. But every time I call, they keep saying someone is going to get back in touch, and I don't hear from anyone. Is there a deadline?
Can you call who? Management?
Yeah, because they actually changed the management from.
Send a letter to management and say, please revise this lease, otherwise I will file a complaint with DHCR requesting that a lease be issued in my name. Send it by certified mail and first class mail with a certificate of mailing. Thank you very much. Are we at 1:30? Yes, we are at 1:30. Miss, last question.
Do you have a card?
I have a card.
I have a question regarding your first lease. If you have a,
Yes.
if you sign a lease and you actually get a preferential,
Can you speak up or move up, for I can barely hear you?
if you sign a first lease with a preferential rent,
Comes from living under all those jet strollers here.
if your first lease is a preferential rent, but you don't know it, you only get the rider for your renewal lease. Is that normal? That's
No, nothing is normal. When it comes to preferential rents, I've seen all kinds of crazy riders, leases, they're all over the place. Nothing is normal in the world of preferential rents. You see your card.
We know that it's a
Yes, nothing is normal. Usually it's in the rider, usually it's a rider attached to preferential. Rarely is it permanently within the person.
it was not written in the first lease, it was written in the video.
Yeah, you should, I mean, what are you gonna do? Let's say yes or no.
3 years out there, look at that, you'll figure out whether or not you're the red building. Okay. The legal registered rent continues to increase each year. The landlord is allowed to use the rent at the registration level. The landlord is only allowed to charge you the rent rate it was frozen at when you first began to receive the street. Report that to all departments, all 311, report that to two departments. It's illegal and it's a fire hazard.
Yesterday, the guy was here, Amy, from the Department of Building, he says he has a copy on it. Yeah. It doesn't matter. They
Call
go,
311. If somebody's got illegal cubicles, illegal rent, again, call 311. That's a real safety hazard. That's a real disaster waiting to happen.
And what kind of, what is it?
when you illegal, when you divide up an
Like
apartment.
a little cubicles and stuff. You build an illegal rooming house. It's a
Yeah.
And
very
you know what?
dangerous
We're
situation.
just saying that, one day I came home and a big red and white sign was on my door.
Vacate order.
Yeah, they wanted to inspect, and when I called, they said they had gotten a complaint that places was being rented out, and they had to come in and inspect. If you didn't get it, if I didn't get in touch with them in a certain amount of time, they would come with a, like a share, order, where they have to come in. But it was the place downstairs, not my place, but they said that they can't do that.
My next article. High-rate vacancy.
Taking my camera too?
No, yo sé que no
Luxury,
es
luxury.
Pero puede hacerlo, él puede hacer casos por día.
Yeah, so what's luxury?
Incluso
Actually, high rate vacancy control.
mi hijo
Automatic.
puede quedarse ahí.